For the past 2 years, as you know, we've seen countless policy changes and regulations starting with Jeff Sessions. I counted the other day how many policy changes, and it was over 6 or 7 pages, and it was above 20. Just in, just since January 2018. And so when you have immigration policies and regulations changing and affecting the way you file cases, it creates a lot of confusion, a lot of chaos. So in a court that already is a very difficult immigration court, we've had a lot of backlog, a lot of cases that have been scheduled but then moved 3 years down the road. We've had attorneys promise to take a case but then realize that if they take this case, it's a 7-year commitment. Suddenly be like, oh no, what's going on? And so we've had to adjust in that way in how we do our casework. We have to probably, before an attorney would take a case from beginning to end, and now we have to do it in bite-sized pieces. So we've had to be creative and innovative at GAIN in order to make sure that our client does not get dropped in the middle. And so we've also taken on more cases. At GAIN, the way we try to do things is 15 to 20% direct representation in-house. We take the more difficult cases. But about 80% is private firms and corporations. We also work with corporations like Delta, Coca-Cola, AT&T, and many others to represent our cases. So we're talking about the behind-the-scenes legal work, but what we've seen even more, and as Conchita has said, are families that are devastated by these new immigration policies. Just the other day, my cousin called me, and she had said that her son's nanny had been attacked by 3 pit bulls and had lost all the blood in her body and is right now at Grady Hospital. And is, every day is a touch and go, and we don't know if she's gonna make it. And members of her family are undocumented. And even though they saw what exactly happened, and it was because the neighbors had 3 pit bulls that they had already been cited for, but just let loose, they are fearful of even saying what's going on. Now, this is a crime that's happened. On top of that, we've seen our human trafficking victims coming forward. That number dramatically decrease. We've seen victims of sexual assault, domestic violence choose to stay in a relationship that they know that is dangerous for them because they're afraid of deportation. That is not acceptable. That is something that in the 20 years I've been doing immigration work makes my heart stop. Because when we know that there are victims out there and we have laws there that should protect them, but we have fear, and we have, honestly, a fear of law enforcement, a fear of deportation, a fear that these laws will not be executed because all these new policies and regulation have labeled our clients as criminals. That's just something that I don't enjoy. And I think all of you will agree with me that if we have laws, then we should also participate in executing those laws for our clients. So it's ironic that, even though our clients are the ones that are labeled as the dangerous one, by putting these laws into place, we're actually creating an unsafe community because people who are witnessing crimes, if they're immigrant, or people who have been affected by crimes are not coming forward. So I'll leave on that, but that's kind of the landscape of what's happening here.
Thank you so much, and thank you for that work. Returning to Priya, so I'm curious how the office goes about, setting its priorities, deciding what to litigate, and relatedly, or if it's not related, you can put. But how do you decide what to defend and what not to defend, right? So what does it mean to say this law is unconstitutional and I'm not going to defend it? Like, what does that look like? What's the standard for how unconstitutional it needs to be?
That's a tricky question. So as a general matter, I think that, and this is different, every attorney general uses differently. So, state to state, it varies. But, when we first got there, this was a question that came up because these things happen. And, as a general matter, I think the boss wants to defend state law, right? Because He's statutorily the only one who is really authorized to do it. He has the right of first refusal. So, if he doesn't do it, a private counsel steps in, the state has to pay money for that. It comes at a real cost. It also comes at a philosophical cost, right? So, we don't defend something because we find the state statute odious or unconstitutional. What's to stop, another attorney general who comes in later decide they aren't going to enforce civil rights laws that the state has in place? What's to stop another attorney general from making a very different choice about what to defend and not defend? And, when the assumption isn't that the state AG defends the lawsuit, there's little stability in the law, right? So like when laws get passed, there's no guarantee to the public that they will actually be enforced if people can decide lightly to not enforce statutes. So for those reasons, there's a presumption of defending statutes. And that is why the office defends a great many things that my boss is on the record as not agreeing with. He has, when he was a state senator, voted against many of the laws that, when they were bills, that he now defends. It's an uncomfortable part of the gig, but it is also, I think, part of the responsibility of being the state AG. Then there is a class of cases where the statute is just simply indefensible. And it's indefensible usually for one of a couple of reasons. One is that, there's case law that, was recently decided that flies in the face of the statute. So one example of this, it predates my boss, but in, I think it was 2014, North Carolina had a ban on gay marriage on the books. And, the state ended up defending the constitutionality of that statute for a little while. And then the Fourth Circuit came out with a decision that said, no, we're not doing this anymore. These statutes are unconstitutional, but the decision was about a similar Virginia statute. It doesn't squarely apply in North Carolina, right? No court had decided that the North Carolina statute was unconstitutional. But, the writing was on the wall, and the Supreme Court was about to decide Windsor. So then Attorney General, now Governor Cooper, decided that he was no longer going to defend the statute and conceded in court. We had to file, I think, an amended answer where we admitted all the allegations and, get out of the lawsuit. Things like that where, sort of the writing's on the wall and another court with authority has decided that a very similar statute is unconstitutional. Those things we decide not to defend. And then we also don't defend cases that are squarely unconstitutional. We have some statutes on the books that are just on the books because they're there. And so a lot of community activists challenge these statutes, the constitutionality of these statutes, and those statutes we will willingly give up. There's a third category of sort of defense that happens, which is when my boss personally feels like the statute is unconstitutional, but there's nothing on the books that makes it very clear. So he will recuse himself from those cases, and staff at the Attorney General's office will continue to defend those cases. So we recently had a trial for challenging state legislative maps as partisan gerrymanders, and under the state constitution. And my boss had come out a long time before that during the Supreme Court case about whether they were unconstitutional partisan gerrymanders under the federal constitution, saying, I believe these are unconstitutional gerrymanders, but they aren't, there's no law that says so clearly, so I can't participate in the defense, but the office is still going to defend. And so that's what the office did. So it's a kind of weird non-defense defense posture, but the statute is defended, my boss is not involved in it, and that's sort of how he threads that needle.
Well, speaking of clearly unconstitutional laws, right? You're litigating against one. It's literally like if you put it on the bar exam, there would be a right answer, right? Which isn't often true in constitutional law, like about many things, but here this is like clearly unconstitutional. And it seems to be clearly in the face of the public will, like in terms of, like if public opinion polling about Roe versus Wade, at least. So I guess how is this happening? I guess how is it that in the face of public opinion, in the face of Roe, that legislatures are feeling so emboldened to do this? And how do we? What does it look like beyond litigation? What does a strategy look like to push back and mobilize the public on these issues?
So I am not a political expert. I'm not hired to be one, and so the things I'm about to say are really just I'm parroting what other people have said. It's been that's a good question. I think there's a few observations. Number one, there's a tremendous, I'm going to say a lot of obvious things. There's a tremendous amount of stigma attached to abortion, as everyone in this room knows. And people who have received abortion care are very understandably reluctant to come out of the closet about that. So apologies for using that terminology. I'm gay, so that's how I think of things. Well, actually, I'm going to risk making an inappropriate analogy, but a lot of it is analogous to the LGBT movement that was able to be successful because people came out of the closet and then everyone knew someone personally who was LGBT. I think the same can be observed here. I would venture to guess that everyone in this room knows someone who has received abortion care, but that many do not know that they know someone who's received abortion care. So I certainly cannot be standing here and telling people to come out of the closet about that for such a sensitive and personal decision, especially since I'm a man. But that's one observation. And in terms of what people can do to combat it, I'm not a messaging expert, but I can tell you what I have been told by messaging experts, including in the ACLU of Georgia. So I think when talking about abortion, as many might not want to do this, I think it's very important that we display respect for the sincerity of those who believe that abortion should be banned, even if historically religions did not see abortion as what many see now, etc. And so what I have said is that everyone is entitled to their own opinion, but every woman is entitled to her own decision. And I think that respects people's opinions, but then acknowledges, though, that your personal, sincere beliefs cannot infringe on the fundamental rights of others. We also talk about not allowing the government to tell women or couples when to start or expand a family. I think that's something everyone can agree with generally. And I think it's important to talk in ways that speak to the fundamental values that everyone shares about autonomy, about family, about making personal decisions regarding your health care. I don't like the word choice. I think choice is like you choose what kind of ice cream flavor you want. These are decisions that are made very seriously and personally. And so I do not use the word choice. And in terms of what lawyers can do to help, I get a lot of emails from lawyers who want to help with this case. I think the best thing that lawyers can do is to move to Georgia and become immigration lawyers. Because, I've often joked that our brief could be one sentence, which is that Roe v. Wade is the controlling law of the land. And, respectfully, we don't need 100 lawyers to do research on that. I'm being flippant and facetious. There's obviously some nuances and complexities in the law, but and of course there are a lot of amicus briefs. But in terms of funneling effort where most is needed, it's in immigration. So that's my dodge.
Nice. Yes, move to Georgia.
Thank you, Sean. I didn't even pay you for that. I know. I will.
No, yeah, and so, I mean, that's a great segue. Yeah, there is so much need. So if you can talk a little bit, Conchita, about this strategy that you adopted in terms of the FTCA. And I'm just curious, how'd you get there? I mean, I guess Bivens is sort of disappearing as an option. But how did you come to this particular strategy, and how can other lawyers help?
Sure. I think our thought process when Suni, our first client, came to us and said she wanted to sue the government was very much to think about, okay, what are all of the possibilities? So yes, we looked into Bivens, we thought about Alien Tort Statute, we thought maybe Rehab Act, and we finally decided to go with an FTCA claim because we felt like there was enough case law that we could not just bring the case, but what was really important for Suni, which I think is important in general for a lot of plaintiffs, was to be able to sue in the District of New Jersey where she was living, rather than having to bring this suit in Texas, right? So that's a big part of why we ended up going with the FTCA, was because of the venue arguments we felt that we could make. And ultimately the government did file a motion to change venue to Texas, which we won, and so now those arguments are much easier to make for future cases because they're able to cite to Suni's case as a precedent for that. Just because these issues kind of hadn't been explored in terms of whether someone who's living in a state who is not a citizen or a permanent resident can, be there, can have venue in their state. And for Suni and her son, we were able to show that they could. And so that was an important legal victory that kind of had nothing to do with the actual underlying claims of the case. And so that was a reason that we chose FTCA. Now that we are, and other organizations have begun to think about these cases and damages lawsuits, there's a lot of different strategies. And so the ACLU recently filed a case that is like a class action based on Bivens, and for families that were separated. So this was the ACLU Immigrants' Rights Project filed this recently. It's going to be interesting to see what happens with that case. I think that it might also be a case that ends up going very slowly, and so there might be a lot of other damages cases that happen before there's any sort of outcome there. But there are other cases where people are exploring, and now ATS claims, which we're also exploring on behalf of some of our clients. And I think it's important to think about what are other ways. But now FTCA has become enough of kind of like a solid option that you're able to say, okay, we're going to bring this case under the FTCA. We can allege a lot of different torts. So we can allege abusive process. Many of the families that we work with are families who, while they were in detention, ICE was coming to them every single day and trying to get them to sign their deportation orders. So we've brought abusive process claims under sort of that kind of fact pattern. We also are not only bringing negligence claims, and we see a lot of medical issues. So Suni's son, who I mentioned, there's another example. He had asthma, and while he was in detention, his inhaler was taken away from him, and he wasn't offered proper medical care. But that's like par for the course. That is happening across the board, right? So thinking through what are the fact patterns, what are the torts, in each state, it can be different. So we've been working under Texas tort law for the most part because that's where most of the people we work with have come through. But there's also Arizona and California, and it might be different. So there's a lot of sort of interesting legal arguments. There's a lot of law to be made. But I think that the reason that we decided to venture down this path beyond just working on Suni's case is really asking ourselves this question of what does it mean to have a right and not be able to vindicate it, right? So how can we tell people that we work with that what happened to them was illegal and then tell them there's nothing we can do to help them hold the government accountable for that? And if we don't do it, there is no private counsel right now that can step in, right? So in the framework of wanting to respond to the communities that we serve, we thought we have to venture down this path. We know that the law is there, and honestly, that's, I think for people like us who have been working in asylum, it's also really helpful even for the attorneys to think about, okay, I know the law on asylum is really bad right now, but like what can we do on the affirmative end to actually expand the law? And maybe there's a world in which if there's a different administration and you have a bunch of these cases pending, you can not just settle for monetary damages, but you can also settle potentially for asylum relief, right? And so there's other sort of creative strategies that I think need to be explored during this time under the Trump administration. And there just aren't a lot of attorneys doing it yet, but I think that hopefully my goal and hope is that 5 years from now we're looking at an entire kind of body of law or area of law, a practice area that a civil rights firm has, and that's just a normal part of their day-to-day work. Unfortunately, it's a normal part of what is happening in government, and maybe if that becomes something that civil rights firms are focused on, if it becomes something that immigrants' rights organizations are thinking through more and more, we can get to a place long-term where the government doesn't think that it is acceptable anymore to have this kind of liability on them, to constantly being sued for issues in detention or things like family separation or not providing proper medical assistance. So that's sort of the thought process behind it.
Great, thank you. I have a lot of questions after, but I will resist because there are questions like, well, under Ziegler versus Abbasi. So anyway, I'll hold off and ask after. So Monica, if you can talk more about how to loop in more of the private bar into these types of cases.
Absolutely. And so if you saw me sitting next to Conchita, I'm really excited because I think Conchita, you're absolutely right. You know, we can represent one client at a time, and we hope we're making change, but I don't know if we are because we're still doing the same thing over and over again. We're hopefully making change for that one individual and their families, but where we need to really make big change, where I think private attorneys want to help, have the expertise to help, and need to jump in, is also in the work that Conchita is doing. Because if we, provide, breakdowns in some of the laws and policies that, the government thinks that they can just go ahead and separate a child, not give medication, not allow visitation hours, whatever they're doing in order to slowly break down our clients who are in detention, that's where we'll see a lot of change. So my goal after this is to also get your number and make sure that we do something like this in Georgia where we have a lot of the detention centers. But back to your question, I tried to loop it in a little bit, is how can the private sector help? Well, the way that you can solve any issue is by having colleagues and partners and collaborators in working in a system that needs that advocacy and representation. So with just taking GAIN, for example, with our clients, any immigrant, unless it's a nonprofit or unless it's, a bar that has an immigrant rights project, no one is given a lawyer like criminal defendants are. And so imagine immigrants advocating for themselves pro bono in a language that they don't understand, in a system that they don't understand. I mean, if anyone has seen Orange is the New Black, you'll see a 2-year-old, advocating for himself in court. That is not the proper way to represent anyone in this really contentious situation. And so the argument for private attorneys to help and represent and change a life has been an easy one, right? There's a lot of law firms that do want to jump in, and now what we're seeing is when law firms have clients in the corporate world, they work on these cases together. It's great for client relations, it's great for team building, that's what they'll say, but in my mind, it's great for my client because my client is receiving representation. But the way you have to do it is you can't just say, hey, we're going to bring in all these attorneys and let them go loose. No, you have to have a really great vetting process for the cases. You have to make sure that the attorneys are trained, and you have to have a supervision and mentoring system throughout the whole entirety of the case, because anything can be dropped. So you have to have that infrastructure when you're doing this type of work, because these cases are, lives are at stake. And so attorneys can be a little bit scared if that's not their area of law. We don't only have immigration attorneys volunteering. We have patent attorneys, or, we have IP attorneys, transactional attorneys. And so when we give advice like technical assistance pretty on a 24/7 kind of hotline basis, that's when they feel supported and they'll do a better job and feel more comfortable in representing our cases. So you have to make sure you have that infrastructure. But the end result of that is you have more people informed in wanting to make change in the system, so that if we could say, hey, we could file for damages, and they've seen firsthand the abuses that your client has suffered, we can build up that network of folks who actually know what's going on and are not like my neighborhood friend who said, did you know that Atlanta has a 3%, grant rate? There are more people in the legal community who are educated, informed, and ready to jump in. And that's the beauty of actually involving the private sector. But you have to do it in a way that they feel supported, so that it's not just all these, attorneys buzzing in and, not really in an orchestrated way.
Thank you.
I just want to add one thing.
And then we'll throw it out to questions.
Yeah, I'm so sorry. I just want to add one thing to what Monica said, which is also that we would never represent someone in an affirmative lawsuit if they didn't have representation in their asylum case. So the work that we're doing, and our organization also does direct client work on asylum cases, it goes hand in hand. It can't be one or the other, in my opinion. It has to really be both if that's what the family, it always has to be the defense of asylum, but if the family wants to move forward with both, I think that that's an important piece of the puzzle. Anyway, I just wanted to add that.
Yeah, absolutely. Thank you. Do we have questions? All right. I think I saw your hand first in the green shirt, William and Mary shirt.
Sure. So my question is about the abortion case specifically, and Sister Song is the plaintiff, the lead plaintiff in the case, and as you know, the Louisiana case is up before the Supreme Court. There is the cross petition by Louisiana to say that providers cannot be plaintiffs.
Right.
That standing question of providers cannot be plaintiffs because, goodness, that's not how we've done abortion cases since 1973.
Right.
What are your thoughts on sort of that argument, and what do you think will happen with that particular portion of that case, given the current state of the court?
So as a general rule, a lot of my ACLU colleagues don't follow this general rule because no one's asking me what my views are. But my general rule is I don't speculate on what the Supreme Court is going to do or what individual justices feel in these kinds of settings. But I will observe that, like, you're right. Just to repeat the question. The question is, in the Louisiana abortion case, the question of third-party standing has been raised, which I believe is, do clinics have standing to bring forward claims on behalf of their patients? I think this calls into, some of you in law school may have heard of next friend status. There's a bunch of class of people who have a very close relationship with people who are harmed, and they have standing, third-party standing to bring those claims. I think a doctor-patient relationship is pretty close. I understand there's some nuances to that argument, but I don't know. But you're right. Courts have accepted for a long time that abortion clinics can bring claims on behalf of their patients. I'll simply add that in our case, doctors at clinics firmly believe that abortion care must be a part of the basic standards of healthcare, and that it would be, some might say it's unethical to not provide that high quality care to their patients, given the raft of different reasons why abortion is necessary. So I'm just going to make that observation. And in our case, you didn't ask this question, but I will just say briefly as a CLE kind of thing, Sister Song's basis for standing as an organization is two independent bases. One is organizational, one is associational. Organizational because they divert resources to combat the law, and associational because they're members, which number thousands across the state, must have access to abortion services.
And the organizational and associational standing law in the 11th Circuit is actually quite good. But it's so, I mean, yeah, that's so remarkable. I mean, Griswold versus Connecticut, Planned Parenthood versus Casey, whole women's health, like this, like over a long span of time, doctors have been plaintiffs in these cases. Yeah, so thank you for that. Are there any other questions? Yes, in the black shirt.
Yeah. Oh, wow. Sorry. Monica, you mentioned how important it is to have really great representation for immigrants in removal proceedings and how you have 3-year-olds going unrepresented. And so I was wondering what your thoughts were on the need for Gideon in immigration.
For
Gideon? Like, well, I can answer
Yeah,
too
go ahead.
first. I think the question is really what we think about having like a public defender system in the context of immigration removal defense or deportation defense. And I personally believe that that's really important. I think that there are really great programs in New York, for example, the New York Family Immigration and Unity Project, NYFIP, which emerged to provide basically public defender type services to detained immigrants in New York City immigration courts. And that was funded by New York City Council, and then it has expanded to now become a statewide project in New York that has funding from the state. I think that that's one really interesting model. I think that other communities have tried to, like San Francisco has like a different model, which is that there's always an attorney at the immigration court in San Francisco that can basically represent someone in kind of like a preliminary or scheduling hearing in an immigration court. So you never, and then once they do that, they do an intake and then find the person a pro bono attorney. So when we work with asylum seekers who live in San Francisco, they say they live in San Francisco, we're like, oh, here's a referral, you're gonna be okay. Also, you just go to immigration court, there's already a lawyer there, it's gonna be totally great. Don't worry, like you're gonna be fine. That's not the case in most places, including in Atlanta. So I think that, yes, it's really, really important. I actually think that that's something that states should be doing right now. That's one of the most important things that I would say a state could do right now or a city could do right now to fight back against sort of the anti-immigrant and anti-asylum seeker sentiments in the country. And so thank you for bringing that up. I think that's a really important advocacy point. And eventually, I think that hopefully there will be space to do that at the federal level as well. There is legislation that specifically talks to this issue of like representing kids in immigration court that Senator Leahy has introduced that, you know, right now obviously is not going to be a time that it passes, but could one day become law. I believe that that should just be the case for everyone.
Yeah. And if I can add, I'm sorry, the word Gideon threw me off for a second. I've been in Atlanta too long in Georgia where we don't have that, but we tried to do that with our local AILA, American Immigration Lawyers Association chapter a few years back, where we tried to have an initiative where we'd have at the docket where they did kids, free immigration lawyer assistance at that time, and then that got squashed. So, and Georgia has not been a state where we get any funding for immigration. I was really jealous when I heard that the state of California gave millions of dollars to immigrant rights organizations, and that hasn't been the case here in Georgia, which is another reason why we are grateful to our private firms and others who help us in this fight, because we don't have that support from the state.
And are there any additional questions?
Over here.
Great. And how are we doing on time? Just to.
You're good.
Okay, great. 5 minutes.
Just to add to the last point about right to counsel, the Vera Institute for Justice has a program called Safe Network, which is taking the New York program and exporting it to other cities, and cities that agree to match funding for universal right to counsel get funding through Vera. And this model, if you go to Vera's website, you can see a map of the cities that have started this program. And In addition to Senator Leahy's bill, there are actually about another half dozen federal bills that address the right to counsel for kids or vulnerable adults or both. If you go to civilrighttocounsel.org, you can find those. We've got them on our website. And also, there are about 24 cities that have created immigration funds for representation, cities or states. And more are coming out every day. It's not the easiest thing to find out because they're not super well publicized, but again, if you are interested, go to our website and find me. I'm the only person whose info is listed. John Pollock, hi. And I'll be happy to share with you the list, which is not public.
Did he say John Paul?
Nice.
Hi, my name is Roia Epps. Everybody calls me Ro. This area of law with immigration issues, specifically with deportation, removal hearings, I've become a lot more interested in. I have 20 years as a social worker before going to law school. I just graduated in July. I've done 2 clinics where I represented indigent defendants, indigent parties who file civil actions, and immigration has come up quite a bit. And on the misdemeanor docket, usually, and I hate to say this, I don't think anybody here is from Detroit. Okay, I'm safe. I mean, from my law clinic. It was where they're trying to rush the docket, and I found that a couple of the clients that I represented, they were either in the process of like finalizing, you know, their citizenship, or I think a couple were undocumented. I just didn't say anything because nobody brought it up. But the concern for me is when we're negotiating, for example, pleas, or whether we should be setting something for trial, I'm always scared is this a deportable offense? And they don't teach you that in law school when your focus is criminal law. Immigration does not come up, but just me knowing the system, you know, as a previous CPS worker, there's 14,000 children in Michigan who are in foster care. Approximately 3,000 are refugee children or, you know, displaced. A lot of our teen girls between 14 and 17 have got caught up in human trafficking. But nobody's tracing them or tracking them. Sometimes their parents have gotten deported and, you know, they're just here in the system. And it breaks my heart to see kids caged like animals in detention centers. So although my focus is criminal law and criminal defense, immigration keeps pulling me there, so I don't want to ignore it. So any advice or suggestions you have, you mentioned AILA. I joined AILA for about a year, and honestly, I didn't get a lot out of AILA. I don't know if Michigan is just not the focus, but we have a large Latino population in Southwest Detroit. We have a large Middle Eastern population in Dearborn and in Hamtramck. Right. So I want to be an asset because it just enrages me that I know a couple of clients that I represented, you know, they possibly have deportable offenses now. So how can, you know, people like me make sure that I'm protecting everybody? Like, I don't want to agree to a deportable offense, but there's no list to tell me this is what can get this person deported or not. So any suggestions you have, because I want to make sure that I'm doing the right thing.
Yes. Well, I'm really glad that you brought that up because I think it's because of a Supreme Court case, Padilla, there is actually an obligation for people who are doing criminal defense work to think about the immigration consequences of those convictions. And so there's an obligation that has now been stated, and every public defender's office, every state, every private criminal defense attorney is, I think, does have the obligation, but are all kind of addressing that obligation in a different way. And so some offices, like I know that the Miami Public Defender's Office, for example, has a Padilla unit that provides advising for all of the other public defenders who have clients who may have immigration consequences of their convictions and is able to help counsel those individuals about whether to take a plea or not. But it's a really, really fundamental I think, part of criminal defense work right now. And I think one of the other ways in which it's really, I've seen a lot of great work is at places like Bronx Defenders or Brooklyn Defenders, that even before the Knife Up program in New York, they were able to provide holistic services. And what that means is that if they represent someone through their criminal defense project, that means that then that person's kind of automatically has immigration, deportation, removal defense counsel if they do end up taking a plea or getting a conviction that gives, that has negative immigration consequences. And so there are lots of models, especially in public defenders' offices, for how to do this right. But ultimately, I think it's one of those places, in a lot of ways like Gideon, this is a related question, and I think, where there was this mandate from the Supreme Court that you had to provide the advising, but then there's no way in which that's actually being made real at the sort of local level. And so I think that it's absolutely critical to keep pushing forward. I think in general, one really good resource is there's oftentimes in a state, I think, at least like one good public defense office that has usually one person who really understands the law, and this is something where it's really important to have it also be about your state, because the law to every state is so different. State law and a lot of the questions about removability in the crim-im context are very dumb and like very specific, and it's just not things that you can kind of export from one state to another. You really have to look at it. Another resource is the Immigrant Defense Project, which is based in New York, but I don't know if they have for Michigan, but they create resources that go conviction by conviction, like misdemeanor and felonies for every state that they've worked with. I think there's at least 10 on their website right now, where it's like a spreadsheet that will tell you, is this a crime of violence? Is this an aggravated felony? Go through all of the different possibilities of the immigration consequences. So I'll think about this more, but this is something that I'm very interested in, so I'm happy to talk about it more.
And if I could just add 30 seconds to that. Here in Atlanta, we only had 5 years ago 3 of those attorneys who were good with crimmigration, criminal, the immigration, and the intersection. And now, 5 years later, we actually have somebody at the Atlanta Public Defender's Office. So there can be movement, but my advice to you is become really good friends with those few immigration attorneys who do criminal law as well, and then it can grow, because I think every public defender's office should have a Padilla unit, like Conchita said. But I know it might seem daunting where you are right now, but get to know them, shadow them, because I think those attorneys would want that as well.
Great, thank you. We could go on and on, but we can't. And so if we can give a round of applause to our wonderful panelists.